Okay, hello. Welcome, everyone. Thank you for joining us for this Jack Miller Center webinar for social studies teachers. Our topic today will be on foreign policy and the U.S. Constitution. What branch gets to do what? The U.S. Constitution on foreign policy and military force. I'm Tom Kelly, the Director of Civic Education Outreach at the Jack Miller Center, and I'm joined by Alberto Cole, the Vincent DePaul Professor of Law at the DePaul University Law School in Chicago. So a few preliminaries before we get started here. Just a note that we will be recording this webinar, so you will all be able to see it afterwards. You can refer back to it. It will be available on the Jack Miller Center YouTube channel. And we'd like for this to be an interactive webinar, as interactive as possible. Of course, we can't see you, that's unfortunate. But you can submit questions through the Q&A box at the bottom of your screen. We encourage you to do so. Professor Cole will be speaking for about 40 minutes once I turn it over to him, and you can feel free during that time to submit questions anytime during that time or during the formal Q&A that will start thereafter at about 5:45. So we welcome your questions. Thank you for completing the poll. We're going to keep that open for a few more minutes. There will be a closing poll that will just ask for some feedback from you all about today's webinar. We appreciate you taking the time to complete that at the end of the session. So the Jack Miller Center is probably new to some of you. I see a few familiar faces here in our list, but for those of you who do not know the Jack Miller Center, we are a Philadelphia-based nonprofit. We support education and the principles of the American founding. We've worked primarily in higher education since roughly the mid-2000s. And in that time, we've been supporting scholars who teach American politics, who teach American history, who teach law, and helping them to advance their teaching and the research and writing that they do on founding documents and ideas. In the last few years, in addition to this work in higher education, we've started to introduce programs that connect scholars in the JMC network with teachers through professional development or graduate coursework that we've introduced on some campuses. So there are a number of really outstanding opportunities for teachers to dig in, deepen your knowledge of American political thought, American constitutional ideas. And I encourage you to check out our Founding Civics webpage, which will appear in the chat. And that page lists upcoming programs that we have. And so we're not active everywhere in the United States, but you'll see the regions where we are active, and I encourage you to check out that page. I also encourage you to check out the Constitutionalist website, which is new. It's Jack Miller Center supported website. And it has a lot of great opinion pieces on contemporary constitutional events from leading scholars in the Jack Miller Center network. So it could be useful to you or for your use in the classroom. I encourage you to check that out. And finally, feel free to contact me if you have questions about the Jack Miller Center or programs that we're doing. I'd love to hear from all of you. And my contacts appearing in the chat. Enough of the preliminaries. We have Alberto Cole joining us all the way from Bolivia. So we're very grateful that he was able to tune in. One of the wonders of Zoom, we can easily do this international webinar, no problem. Professor Cole is an expert on international law, human rights, US foreign relations, and terrorism. He's held academic posts at Georgetown University, the Naval War College, and he served as Dean for the Center for Naval War Studies for a number of years before arriving at DePaul. But Professor Cole also has, Professor Cole also has outstanding government experience. He worked from 1990 to 1993 for the Pentagon, working on policy, strategy, and helping to oversee a $3 billion budget on special operations forces and counterterrorism. So Professor Coles both understands the academic side of things and has actually worked and practiced in government and also internationally. In 2004, he won the Antonio Jose Irizarry Medal for strengthening the rule of law and civilian control over the military in Guatemala. So a wealth of experience and knowledge to bring with us today. And I turn it over to you, Alberto.
Thank you, Tom. Thank you for such a generous introduction, and my warmest thanks to the Jack Miller Center for sponsoring this program. And also my warmest thanks to all of you who have tuned in for this webinar. We are going to talk about what I think is one of the most fundamental questions facing our government every day, and that is the conduct of foreign policy, the conduct of foreign relations, including, but not only, the decision on when the United States should use military force in an increasingly dangerous, unstable, and unpredictable world. In fact, as I like to tell my students, our lives are most likely to be upended sometime in the next 10, 20, 30 years by a major foreign policy event, perhaps even a catastrophic war, than it is by just about any other event that we often see publicized in our media today. So yes, I do worry about climate change. I do worry about domestic issues in the United States. But the one thing that could really wreak havoc in some very harsh and horrible ways in our lives and in the lives of our children would be a major war in which the United States would involve itself. So therefore, understanding foreign policy and understanding the Constitution of the United States and its framework for handling foreign policy is of the utmost importance, not only for us as citizens, but also for us as educators who are trying to educate a younger generation to assume the duties of citizenship. So let's begin. Let's begin by looking at the Constitution and looking at how the Constitution deals with the issues of foreign relations. So I'm going to do a little bit of screen sharing now and turn this over to this presentation in terms of a more formal set of issues. But so the first thing that I want to emphasize here, let me go on full screen here first. Here we go. Okay, so who gets to do what and when? Okay, so the first thing I want to say is that the reason the Constitution of the United States was put together in the first place, and this may surprise you, was because of foreign affairs. In other words, we think about the Constitution in terms of the wonderful Bill of Rights and the rights and freedoms that it guarantees, all of which is true. But we forget that for the founders back in 1787, the most important reason why they felt we needed a federal constitution and why we got the Constitution that we have today was because of this thing called foreign affairs. And, in the Federalist Papers, which Madison, Hamilton, and Jay wrote to explain why we needed a constitution, because at that time there were many people who thought we did not need a constitution, that we should remain 13 states in this loose confederation. But Madison and Hamilton in particular said we need a federal union and we need a federal constitution because these 13 states are operating not in a vacuum. And this, again, is something that we want to make sure we understand. The United States does not exist in a vacuum. The United States exists in the middle of a complicated, dangerous world. And the same was true in 1787. 13 states were operating in an international system where they were surrounded by much more powerful, ambitious, grasping European great powers. So foreign policy, first and foremost, Great Britain, France, Spain, even Russia, the powerful Russian Empire, all of these major European powers had designs on North America, including, of course, on the territory occupied by the 13 colonies. And the founders were worried that these great powers would play divide and conquer among the newly independent, heavily indebted, militarily weak 13 states, and eventually wind up dominating them, or at a minimum, they would turn them into what today we would call satellite states, or traditionally vassal states, weak, subservient states serving their interests. In addition to that, Hamilton and Madison also argued, look, only a federal government with taxing powers and a chief executive could build a strong navy to protect the United States. Only a federal government with taxing powers and a chief executive could negotiate commercially advantageous trade deals with powerful European trading rivals, such as Great Britain and France. And finally, only a federal government could carry out a single unified foreign policy to keep the United States out of European wars. In other words, to keep us from becoming pawns in Europe's power rivalries, and also to defend our interests. So foreign policy concerns were the chief driver to put together this federal union and this document that we know as the Constitution of the United States, which finally was adopted by the states in 1787, and under which we enjoy the blessings of order and liberty to this day. Now let's just go over some key constitutional principles, and so that we can better understand the Constitution's framework for foreign policy and the use of military force. So of course, first and foremost, separation of powers into three co-equal independent branches. So, you know, the United States, unlike other states around the world, separates power. We do not accept the Rousseauian vision of a general will of one single power dominating government and dominating society. We think that power should be separated, and that these three branches are independent of each other and should be co-equal. Moreover, in Article 1, the Congress gets only limited enumerated delegated powers. In other words, the federal government wasn't just set up to do whatever it thought it should do, okay? The idea was, we're going to give the federal government, we're going to give Congress only some specific powers and nothing beyond that. So the powers are limited and they are enumerated. Congress gets X, Y, Z, can only do these particular things. And these powers are delegated to the Congress and to the federal government by the states, which are the entities that put this union together. In Article 2, of course, we have an executive branch, which gets executive power vested in the president. And we're going to look at this in a little bit more detail in a couple of minutes. And then finally, Article 3, you see how logical it is. Article 1, Congress. Article 2, the executive. And then Article 3, another co-equal independent branch of government, the federal judiciary. And its job, its function, is to hear cases and controversies dealing with three kinds of subjects. Number one, the Constitution of the United States. Number two, the laws of the United States, that is federal statutes, that is laws passed by Congress. And number three, treaties entered into by the United States. So those three are the grounds for the federal judiciary in the Constitution. Okay. Other constitutional principles, okay? Federalism, the idea that all powers that are not specifically granted to the federal government by the Constitution, unless they're specifically granted to the federal government by the Constitution, those powers remain with the states and with the people. And that's, of course, that was codified in the 10th Amendment. People wanted to make sure that that was written very clearly. That leads me to my next point, which is that in our system, Okay, keep in mind, states retain powers over most matters affecting people's everyday lives, including police powers. In other words, there is no such thing as a general police power for the federal government. The federal government doesn't just get to keep law and order as a general matter. The police powers, the general police powers, all rest with the states, as do most areas of the law that shape your lives and my life day in and day out. Criminal law, torts, contracts, family law, property law, inheritances, insurance, you name it. All of that remains in the hands of the states. Okay, so let's look in greater detail about who gets to do what, okay, under our system. That's Article 1, very logically, Congress, okay? First and foremost, Congress makes the laws, okay? And this is a fundamental thing to understand, okay? The United States Constitution, presidents don't make laws, okay? Even though recently we have seen an increasing tendency on the part of presidents to try to make laws through these things called executive orders. But the reality is that under the Constitution, the only entity that has the power to actually make laws, laws under which you have to pay taxes, laws under which you may have to go to prison if you break it, laws under which you may have to pay a fine if you break it, only Congress can do that. Only Congress can make the laws, okay? And then, of course, some tremendously important power, the power to tax. Congress has that, not the president. The power to spend. And notice, all revenue bills must originate in the House, not in the Senate, in the House. The idea is that these people who are elected every 2 years, okay, are representatives. Those are the people who have to write up the original revenue bills, okay? And in fact, not a dollar can be spent by the US Treasury unless it has first been approved, appropriated by the Congress of the United States. The president cannot just spend on her own, on his own money, unless it has first been appropriated by Congress. Then, of course, Congress, gets to do some other amazingly important things like regulate commerce of foreign nations. The Congress of the United States, okay, has the power under the Constitution to tell any of us that we cannot buy things from a particular country or that we cannot sell things to a particular country. Indeed, Congress has the power to tell each of us that we cannot go to or travel to a particular country. There's no constitutional right to travel to a foreign country. There's no constitutional right to trade with a foreign country, okay? Congress, according to the Constitution, has the power to regulate all of that. Now, occasionally they will delegate some of that power to the president, but again, only because Congress wishes to do so, okay? And then, of course, Congress has the power to raise an army and a navy, meaning the president doesn't get to decide how large our army or our navy or our Marine Corps or Air Force is. Congress does that, okay? And if tomorrow Congress wanted to, they could say, look, we're going to get rid of all the aircraft carriers, or look, we're going to have 40 aircraft carriers instead of 12, okay, or 10, okay. That's within the purview of Congress. Very importantly, also the power to suspend habeas corpus. Okay, and we could spend a whole afternoon talking about habeas corpus, but habeas corpus is probably the most fundamental civil right in the United States. It is so fundamental, in fact, that the Constitution only refers to it in passing, because the drafters of the Constitution assumed that everybody at that time knew what habeas corpus was, and that everybody, of course, understood that that was the most fundamental right of an Englishman and of an American. And habeas corpus is a writ that you get to ask a judge to issue if the government detains you If the government detains you, the government has to bring you before a judge. And that's the right of habeas corpus, okay? You cannot be detained by a government official and simply be put away. The government, as soon as it detains you, has to bring you before a judge, okay? Not a military commander, but a judge. And only Congress has the power to suspend that constitutional right, okay? Which, as I said, is not in the Bill of Rights, is not in a separate article. It is only mentioned in passing with reference to Congress's power to suspend it. Congress, of course, gets to also has the power to make rules for the Army and Navy, okay? So again, Congress gets to make all the rules about how the Army and Navy are regulated, all right? And of course, very fundamentally, the power to declare war, okay? And we'll be talking in a few minutes about what that means, okay? But certainly the founders, if you look at their discussions after the Constitution was put together, understood that Congress's power to declare war meant that the United States president cannot put the United States of America in a war. A war meaning, a state of hostilities with a foreign power, unless Congress first has declared war, okay? And again, we will look at this in greater detail in a couple of minutes. Also, Congress has the power to issue letters of marque and reprisal, which means that in theory, to this day, Congress could give any of us a letter authorizing us to seize foreign enemy ships. And we could do that with that letter, and we would not be considered a pirate under international law, okay? Similarly, Congress could issue to any of us a letter authorizing us to go and capture a terrorist somewhere overseas, okay? They could do that if they wanted to. They don't do that nowadays because Congress does not want American citizens to get into a lot of trouble and then force the US military to come to our rescue. But certainly in the 18th century and early part of the 19th century, the Congress would issue these letters of marque authorizing American citizens to seize the ships of foreign nations with which the United States was in hostilities, okay? And then this is very fundamental, okay? Congress is given the power to establish a uniform rule of naturalization, meaning Congress has the power to set out the rules about how people become naturalized citizens of the United States. And since the 1880s, the Supreme Court of the United States has interpreted this to mean that Congress has absolute power over immigration, okay? So let's make it very clear, okay? Immigration into the United States is not a human right. Okay? No one has a right to come to this country. And Congress has an absolute power to decide who gets to come in, when, and how. And in fact, if Congress wants to keep out a particular group of people, for whatever reason it chooses, under the Constitution, Congress has an absolute power to do that, okay? Now, within Congress, of course, there's the House and the Senate. The Senate has 100 members, the Senate, 2 members for each state of our 50 states. And the Senate has a special role within our constitutional system beyond the role of Congress as a whole, okay? And here are 3 major ones, okay? So Congress gets to approve treaties, to give its advice and consent to treaties. The president makes the treaties, okay? Congress cannot make treaties. The Senate cannot make treaties, If today every single member of the Congress of the United States, including every single senator, wanted to enter into a treaty with Russia, let's say, or with Germany, they would not be able to do that, okay? The president, only the president can make a treaty. But the treaty does not become binding on the United States unless the Senate, not the whole Congress, just the Senate gives its advice and consent by 2/3 of all members at the time the vote takes place. Usually all of them show up, all 100 of them today, okay? But if on a particular day when the vote takes place, only 60 show up, it would be 2/3 of all those 60. Okay? And then, of course, Congress gets to confirm all cabinet members, as well as senior officials of the executive branch, up to, you know, pretty much the assistant secretary level and a number of other Senate confirmed political appointments. And then, of course, the Senate, not the Congress, the Senate gets to confirm all ambassadors, all federal judges, and general officers of the United States Armed Forces, generals and admirals. Okay, they have to be approved. They have to be confirmed by the Senate. Okay, general officers. Now let's look at the president. Under Article 2, who gets to do what? The president. Okay, so Article 2 actually simply starts out by saying the executive power shall be vested in a president of the United States. What exactly does that mean? What exactly does that mean? Okay. And the idea here is that whatever thing lies in the executive power, whatever is required in terms of executing the laws of the United States or executing the policies of the United States, that gets to be done by the president, not by Congress, not by federal judges, okay? So neither Congress nor federal judges can execute the laws or can execute policies. That belongs with the executive power in the president. Also, you know, the president shall be commander-in-chief of the Army and Navy. Today, you know, that would mean all the armed forces, okay? But remember, commander-in-chief of the Army and Navy that Congress gives the president, okay? So if the Congress wants to give the president only 2 tanks and only 3 ships, tough luck. That's what the president gets to be commander-in-chief of, okay? But the president does command it, and it is none of the business of Congress to give operational orders, okay, to the Army or to the Navy, you know, to move regiments, to move ships. None of that is within the Congress power. Only the president as commander-in-chief gets to do that. And of course, as I mentioned earlier, presidents have the power to make treaties, okay? They get to make the treaties, they get to negotiate them. Of course, for the treaty to be binding, they need the advice and consent of 2/3 of all senators present, okay? So the president also gets to receive ambassadors and other public ministers. This is all language from the Constitution, okay? So receive ambassadors. So let's say that today, okay, the nation of Catalonia were to send an ambassador to the United States. What do you think President Biden would do? Well, President Biden would not receive the ambassador from Catalonia, okay? And that would be the way for President Biden to tell Catalonia, we do not recognize Catalonia as an independent state. Same thing with Scotland. You know, if Scotland wanted to send an ambassador to the United States today, the president would not receive that ambassador, would say, you know, I will not receive you as an ambassador. And that would be a way of saying, we do not recognize Scotland as an independent state. And of course, the president also gets to appoint ambassadors or the public ministers and consuls, okay? So that's a way for the president to recognize a particular country and also to recognize its government and also to have relations with that government. So, for example, you know, back in the 1930s, at one point, President Franklin Roosevelt decided to appoint an ambassador to the Soviet Union. And that was part of the president's decision to recognize the Soviet Union as an entity and to recognize its communist government as an entity and to have relations, diplomatic relations with. That's a presidential decision that the president makes by appointing ambassadors or other public ministers and consuls to a particular entity. And that recognition power, by the way, includes also the president not only has the power to recognize the state of Israel, the president also has the power to say, you know, we, the United States of America, recognize Jerusalem as the capital of Israel, which is exactly what President Trump did a few years ago when he moved our embassy to Jerusalem. Before that, previous American presidents did not recognize Jerusalem as the capital of Israel. And again, that was the president's policy, president's power to do that or not to do that. So far, President Biden is keeping the American embassy in Israel in Jerusalem. So this president also recognizes Jerusalem as the capital of Israel. Other states around the world don't do that, but the United States of America does. And that is something that the president decides, not Congress. Okay. And finally, of course, the president gets to commission all the officers of the United States. Okay. So every single officer, including military officers that have a commission, from the humblest lieutenant to the highest ranking admiral or general, they get their commissions from the president. Though remember, in the case of admirals and generals, those appointments get to be confirmed by the Senate. Okay. And here come two major powers the president also have. Okay. So the first one is really fundamental, and it's one over which we argue all the time. The president shall take care that the laws be faithfully executed. Okay. And of course, there's always controversy on this issue because Congress passes a law, and then the question is, how do we make sure that the president takes care that that law is faithfully executed and that the president doesn't simply just set the law aside and say, sorry, you know, I'm doing my best, but I cannot enforce this law. These are very serious constitutional issues on which there are no clear scientific answers. But nevertheless, there it is, the obligation that the president has to make sure that the laws are not executed, faithfully executed. Okay, so very, very major responsibility. And then finally, of course, as we've become quite familiar over the past few years, the president has the power to grant reprieves and pardons for offenses against the United States. And that power is plenary, okay? There are no limits on that power, okay? But again, only for offenses against the United States, okay? So if somebody commits a crime under the laws of the state of Texas, the president cannot pardon that person for an offense against the laws of the state of Texas. But any offenses against the United States, any federal offenses, any federal crimes, the president has absolute power to grant pardons for such offenses. Okay. Now, there are two different views of presidential power. And this is always a clash. And it's so interesting because depending on which party is in power. So when the Democrats are in power, all of a sudden they become very strong advocates of strong presidential power. When the Republicans are in power, then the Democrats become very, very critical of broad readings of presidential power. But these views obviously go beyond parties. And so one view of presidential power is to look at the vesting clause. Remember the vesting clause? You know, the executive power shall be vested in a president. Okay. So one view is to say the president can only do what the Constitution specifically authorizes him to do. And that was, of course, the viewpoint of a very distinguished Republican president, William Howard Taft, who went on to become Chief Justice of the Supreme Court of the United States after the presidency. Okay? And then there's a broad reading of the vesting clause. And that is the president can do anything and everything that is not prohibited by the Constitution or that is not delegated by the Constitution to either the courts or Congress. And that's Theodore Roosevelt, Taft's predecessor, also a Republican, very, very famous and distinguished president. So you see these two different readings of the vesting clause, okay? One saying the president only can do what the Constitution specifically gives the president to do. The other one saying, well, no. The vesting clause means the president as chief executive gets to do anything and everything unless the Constitution prohibits him from doing that, or unless the Constitution says, no, 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 that is the power of Congress or of the courts. Okay, so you see those two differences. Very, very fundamental. Okay. Now, with regards to foreign affairs, okay, with regards to foreign affairs, the prevailing view has been over the past, 75 years or so, 80 years. The one stated in United States versus Curtis Wright, 1937, very famous Supreme Court case involving, incidentally, Bolivia, where I am right now for a few weeks. Okay, and that is in the field of foreign affairs, as opposed to domestic matters, the president gets to do anything and everything not specifically prohibited by the Constitution or assigned by the Constitution to another branch. Now remember, this is in the field of foreign affairs only, as opposed to domestic matters. In domestic matters, the president is bound much more strictly, as is Congress, because in domestic matters, Congress can only do what it is specifically delegated to do, what its enumerated powers say it can do, and no more. But in the field of foreign affairs, the Supreme Court in this case argued that the president gets to do anything and everything not specifically prohibited by the Constitution or assigned to another branch. And the theory behind this is that foreign policy power passed from the British Crown to the president when the Constitution was drafted, and that the field of foreign affairs is a field in which the executive has literally unbounded plenary power, a power that can be bounded only by the Constitution. And of course, if the Constitution says, look, President, you can only implement a treaty with the advice and consent of the Senate, then of course, it's got to be done that way, okay? Or time out, President, matters of foreign commerce, foreign trade are regulated by Congress, not the president. Okay, the president has to step aside, okay? But with regards to foreign policy in general, unless prohibited by the Constitution specifically or assigned to another branch, the president gets to do it, okay? And in a subsequent case, Youngstown Steel versus Sawyer, the Supreme Court, dealt with that issue. This was during the Korean War, and the steel industry was about to go into a strike. The workers and the steel companies could not agree. And so President Truman said, look, I'm commander-in-chief. We're in the middle of a war. Therefore, I'm going to ask the Secretary of Commerce to take over the steel mills during the duration of the war and run them. And of course, this is foreign affairs. And the Supreme Court said, not so fast, Mr. President. Seizing domestic factories of steel is not a foreign affairs matter. That's a domestic matter. And to do that, Mr. President, you need a law. Remember, Mr. President, you don't make the laws. Congress makes the laws. So if you're going to seize a factory that makes steel in the United States in the middle of a war, that is not a foreign affair matter. That is a domestic property taking. And to do that, Congress has to pass the law and Congress has to authorize that, okay? Okay, let's look at some big issues now in terms of this framework. Big issues that all of you as citizens, as high school teachers, have been familiar with over the last few years in terms of all kinds of debates in our country. Okay, so first of all, the issue of immigration. So you'll recall that when President Trump came into office, he issued an executive order banning individuals from certain countries from entering the United States, okay? And at first the orders were a little too broad because they also included, legal residents, persons who already had been authorized to be legal residents of the United States. But ultimately, the president prevailed in court. And the Supreme Court of the United States said, look, Congress gets to regulate immigration. Congress gets to decide who gets to come in, who gets to stay out of the United States. In fact, I'm going to say something very shocking, okay? Congress right now could pass a law saying, and I'm going to say this because I was born and raised in Cuba, so I will not be offending anybody other than myself. So Congress can say, we will not allow any Cubans to come into the United States anymore because we don't like them, period. Okay? And it doesn't matter whether you think this is racist or xenophobic or whatever. Congress has the power to do that, okay? Because people outside the United States do not enjoy the protection of the Constitution of the United States, okay? And therefore, Congress can ban anybody from coming into the United States for whatever reason, no matter how morally objectionable we may find that reason to be. Now, in this particular case, Congress had said, years ago, had given to the president the power to prevent the entry into the United States of any person or group of persons that the president deemed to be a threat to our national security or against our interests. And so the president said, look, people from these particular countries, we don't want them coming into the United States right now because those countries do not have the kinds of systems in place that could screen out potential terrorists. So therefore, for that reason, I don't want to allow people from those countries to come into the United States. Of course, you know, President Trump's enemies said what he's trying to do here is to ban Muslims from coming into the United States. You know, the administration responded, look, that is not the case because we're still allowing persons from Egypt coming in. We're still allowing persons of Muslim faith from India coming in, Indonesia. But we're not allowing persons from countries where we believe the governments don't have screening systems in place to properly screen people that might be a danger to us. And therefore, under the power of Congress, which Congress delegated to the president could say, I am keeping people from these countries out of the United States. And the Supreme Court upheld those orders, okay? Now, President Biden recently reversed those executive orders, but again, that was a presidential power delegated to the president by Congress, okay? Now remember, okay, foreign policy powers, the president's powers are broad, again, except for international trade. That is the Congress's power to regulate, as well as, of course, the making of treaties. And, you know, the Senate of the United States always insists, if the United States is going to enter into a treaty, okay, the Senate of the United States has to give its advice and consent. The president cannot enter into a treaty by himself, okay? And of course, the power to recognize foreign governments, to establish American foreign policy, no matter how bad or how good you think that American foreign policy may be, that is the president's power, okay? Now, some recent cases, okay? Notice, you know, this is the famous Paris Climate Accords, okay? One of the first things that President Trump did was he issued an executive order getting us out of the Paris Climate Accords. And one of the first things that President Biden did when he came into office was to announce that we were rejoining the Paris Climate Accord. Okay. But notice, this is not known as the Paris Climate Treaty. And that's because it's not a treaty. You know, the media can get very sloppy. Sometimes they've talked about the Paris Climate Treaty, but officially, it is an accord. It is no more than a political commitment. It is no more than the United States saying, we will try to do X, Y, Z, but it is not a legally binding obligation. And the reason it's not a treaty is that President Obama, who negotiated this in 2015, knew he could not get 2/3 of the US Senate to give its advice and consent to it. And because it was not a treaty, of course, also was very easy for the next president, President Trump, to say, well, we're getting out of it. I don't want to make a political commitment to do this. And remember, in international relations, political commitments are one thing. The president can make a political commitment, say, we will support the state of Israel. That's a political commitment, right? We will support the state of Israel. Another thing is to enter into a treaty with Israel, guaranteeing their security. That would be a legally binding obligation. And that, of course, would require the United States Senate by 2/3 to agree with it. And then, of course, we have the Iran nuclear deal. It's not even, that's the term that we usually see out there. It's not even a deal. It is a framework. So it's really known as the joint framework because, again, it's a political commitment. Again, President Obama knew he could not get an Iran nuclear arms control treaty through the Senate. So it's basically a commitment. The United States says, well, we will do X, Y, Z in case we see Iran doing X, Y, Z. And all the other parties to that framework basically are making political commitments to, including Iran. And then, of course, that was also the reason as soon as President Trump came in, he got us out of that framework. And now President Biden is trying to negotiate a framework that will essentially, in his view, slow down Iran's acquisition of nuclear weapons. But again, it's not a treaty, and it is simply a political commitment, and any president following it could suspend it, and it is not legally binding. It is simply a political commitment.
Alberto?
Yes, go ahead, Tom.
Sorry to interrupt, but we have about 10 minutes left, 10 or 11 minutes. And
okay.
I wonder if I could just stop you here as you move on to the next slide. I know you have a few more slides in your presentation, but we did receive a few questions beforehand, and I think some of the issues that you were going to address in the next slides relate to those questions. And the first is actually about what you've just pulled up here, which is Congress has not declared war officially, right? I believe since the Second World War.
Since the Second World War, correct.
So, but the U.S. has been involved in hostilities, many times since that time. So why is that the case? Why has Congress, authorized military force in some cases, but not attempted to declare war or declined to declare war? I guess if they could do that, how should we understand Congress's power, given their reticence to use that power in the last 70 years or so?
Yes. So the consensus that has emerged is that in the case of the Vietnam War, for example, Congress did not want to declare war because we did not want to declare war on North Vietnam because we thought that the Johnson administration did not want to turn this into a formal major World War II style war. And in fact, the Johnson administration was afraid that if we declared war in North Vietnam, China would intervene in that war, and then we would be at war with China as we were during the Korean War, with some very unpleasant and horrible consequences for the United States. Okay, so but what Congress has done, Tom, is they say the fact that we don't declare war doesn't mean that we still don't have the power to authorize a war. Okay, and so what you see is that when the use of force is big enough, when it involves deploying large numbers of American troops, taking big risks, and also spending huge amounts of money, Congress has passed the equivalent of resolutions authorizing such a use of force. Congress did that in the Vietnam War with the Gulf of Tonkin resolution. It did that with the Persian Gulf War, 1991. I was at the Pentagon at that time. Congress authorized that war, and Congress also authorized the Iraq War. Most of us don't agree with the Iraq War. We think it was a disaster. President Trump has said that many times, and as many Democrats have also, as one of the few things on which President Trump and Barack Obama agreed on, which was the Iraq War was a disaster. But that war was authorized by Congress, okay? And then there are uses of force that fall short of a big use of American force, short of a big deployment of lots of American troops for a prolonged period of time with massive investments of money. And that would be the invasions of Grenada, invasion of Panama, and of course the targeted killings, the use of targeted killings of individuals abroad. So this is the consensus that has emerged. Tom, if you give me a minute to just summarize what the consensus is. The president has the power to respond to an attack. That has been very clear since the Price cases during the US Civil War, the 1860s, okay? So we're attacked, the president has the power to respond. The president also has the power to protect US citizens abroad. The president also can use limited force. Notice the word limited in support of US foreign policy objectives. Libya 2011, no American troops deployed on the ground. The campaign against ISIS, a few thousand American advisors, not engaged in direct combat. They were only training our Kurdish allies who were fighting ISIS. The killing of Qasem Soleimani by President Trump in 2019, that was, sending a drone. Okay, that there's a consensus that that's acceptable. So president can use limited force to target and kill persons abroad, planning attacks against the U.S., including U.S. citizens. Famous case, very controversial. AlAwlaki versus Obama. Mr. AlAwlaki was a U.S. citizen who went overseas and became involved in terrorist groups planning attacks against the United States. The president of the United States put him on a kill list and eventually had him killed with a drone strike. Of course, very famously, the military raid to kill Osama bin Laden in Pakistan. Congress did not authorize that. And of course, the raid against Soleimani I just mentioned. But all of these, remember, involved very limited force, very limited deployments of U.S. force, in some cases, no U.S. Ground troops involved, very limited time frame, very limited risk, no risk of major escalation, and also very limited expenditures of taxpayers' funds. But big uses of force involving major deployments of U.S. troops and expenditures amounting to the classic definition of a war require congressional authorization. And that's kind of the consensus. Now, presidents formally do not like that last paragraph, but that is, I would argue, that is still in line with the wording and the spirit of Article 1 of the Constitution that gives Congress the power to declare war, which the founders, by the way, and presidents all the way up to Abraham Lincoln understood to be the power to put the United States into a war meaning a big use of force where you risk a lot of American lives and spend a lot of taxpayers' money.
Alberto, is there like a borderline? What would be the most borderline case, between what would be considered limited? I mean, if you could think of it, between what would be considered limited and major.
Well, we really haven't. I think the early stages of the Vietnam War were that, but that's why when Lyndon Johnson decided to go big time, he asked Congress for the Gulf War, for the Gulf of Tonkin resolution. Okay. We haven't had it, any kind of borderline cases recently. I mean, if you think about, again, the ISIS, that was, against U.S. advisors, just not U.S. engaging in direct combat with other forces. And, going back beyond that, the invasion of Panama, maybe, we invaded a sovereign country, okay? We used a little over 20,000 U.S. troops. It was very fast, and it ended very quickly. And so President Bush said this is a very limited use of force for very limited ends, and then we ended that involvement right away.
We did have one other question from
Yes.
before the session about the War Powers Resolution. So
Yes.
Congress asserted itself there to limit presidential power to some extent. Nixon wasn't very happy about that. He tried to veto the resolution, or he did veto the resolution. How should we understand the significance of the War Powers Resolution and how it's played out since?
Okay, so the War Powers Resolution. So if you're a very faithful constitutionalist, conservative, you don't like it because you say you don't need the War Powers Resolution because, the War Powers Resolution simply repeats what's already in the Constitution. On the other hand, if you're a big advocate of presidential power and executive power, even the power to put us into a war, you also don't like it because it reminds the president that the president is limited. Presidents never have acknowledged the constitutionality of the War Powers Resolution. Congress never has pushed the issue. But in closing, let me put before our viewers something that I think is the biggest problem we have, which is that today the President of the United States can put the United States into a devastating nuclear war with a foreign power in 30 minutes without any congressional authorization. And that's something that a lot of very thoughtful people have tried to wrap their heads around. It's been very, very difficult to deal with that problem, including, Senator Corker most recently. He's retired now, but very thoughtful, the chair of the Senate Foreign Relations Committee. I'd say, is there a way we can put some limits on the president's power to do this? And nobody in the Senate is really prepared to do that. But that's the great paradox, Tom, that, the president, we know about the nuclear football, the military officers that shout as the president every, 24/7. I had a student of mine at the War College who had been President Ronald Reagan's carrier of the nuclear football, with all the nuclear codes. But we could have a crisis. We could have a crisis brought about by the president's own recklessness, in which the president makes the decision that he needs to order an anticipatory nuclear attack against an enemy in self-defense. And he could do that in 30 minutes without any congressional authorization. Okay. So it brings us back to a fundamental point that the founders made, which is that the Constitution is terribly important. But in the end, you need some measure, some at least limited measure of wisdom on the part of the persons who hold the executive office of the United States of America.
We're at 6 o'clock, and I want to thank everyone for joining us. And I thank Alberto, of course, for the wonderful presentation. Alberto very graciously said that we could make the slides that he presented available to teachers. So please reach out to me, and we can share those slides with you. And as I mentioned, the session will be available on YouTube as of tomorrow, I believe, on the Jack Miller Center YouTube channel. So if you'd like to look back, please take a look back. Alberto, everyone can feel free to leave as they like, but you offered to stay a couple of extra minutes.
Yes,
I did
absolutely.
Have one additional question that I wanted to ask you, which is about targeted killings and
Yes.
I guess, and where they can happen. So we know that, multiple presidents have engaged in targeted killing, Republicans and Democrats. And we know that typically, the justification is an imminent threat to the United States, or, there's evidence that this person poses some kind of imminent threat. Where can those targeted killings take place? I mean, could they take place in any country? What does international law have to say about it? What does constitutional law have to say about it?
Okay, so first of all, so international law, it depends on who you talk to. There are some international lawyers who are very, I would call them very strict, and say, targeted killings are illegal. But there are plenty of international lawyers, Tom, who would argue that there are parts of the world today, okay, Tom, in which governments do not have authority to control that territory. So, you could take parts of Yemen, parts of Afghanistan, even, sections of, large sections in Asia and Africa, particularly East Africa, where there is not a government that can control that territory. And so terrorists can operate freely in that area. And since that government is not exercising its primary obligation under international law, which is to prevent its territory from being used as a way of attacking a country with which is at peace, then the United States has no other remedy in self-defense but to respond. And so that's the justification. We're acting in self-defense, and we're acting, we don't do this in France, we don't do this in Egypt, we don't do this in China, of course, or even Vietnam, or we do that only in areas of the world where there is no effective state authority, okay? Even though the government is the government of a country with which we're at peace, okay? And then secondly, the president says, look, this particular individual, the AlAwlaki case is very troubling for many people because AlAwlaki was a US citizen. But he left the US and he started becoming involved with these groups, and he was involved in operational planning for carrying out attacks against the United States. Okay, so the president of the United States, what is the president going to do? Okay, the president cannot ask to have AlAwlaki extradited. You know, AlAwlaki is not going to turn himself in. The government of Yemen is not going to be able to arrest AlAwlaki. Okay, so the president says, look, we give him an opportunity to turn himself in. He won't turn himself in. We put him on the kill list, and we treat him as we would treat any enemy combatant, anybody who takes up arms against the United States, even if they're citizens of the United States. If they're outside the territory of the United States where we cannot arrest them, okay, and put them in prison and bring him before a federal judge for a federal trial, if we cannot do that because they're outside the United States, as president of the United States, I have a responsibility to defend the Constitution. And that means with proper intelligence, vetted by my lawyers, screened by a series of levels of intelligence officials, I put him on the kill list, and we're going to kill him. You know, a lot of people disagree with that, but you could see also why, if you were sitting behind the resolute desk in the White House, you would see that there are exceptional cases, of course, where this is something that the president has a responsibility to do. And of course, this is what President Trump did with, AlAwlaki was killed under President Obama's orders. And then President Trump did something very similar with the Iranian commander, Qasem Soleimani. Look, this is somebody who's going around directing, coordinating attacks against American forces. And they're acting as an enemy of the United States. And I'm going to protect the people of the United States and the Constitution of the United States. That's the justification. Controversial, but it's interesting that White Houses from both parties have made that very similar argument.
Mm. Well, thank you so much, Alberto. Thank you for staying for a few extra minutes, and we really appreciate your time with us. And thanks, everyone. We'll see you all later, we hope.
Okay. Have a wonderful day. Thank you. Thank you all.
Bye.